10 important contract clauses. Depending on the transaction, contracts can be exceptionally long and will usually include a lot of language to protect the interests of one or both parties. Although not all contract clauses are always enforceable, below are some common contract clauses that are present in most contracts. 1. Choice of law and forum. Most contracts that are prepared by attorneys include a clause that dictates the state and county of any civil matters that arise from the contract. In addition to describing the location of any future litigation, the language of the contract will also determine which state's laws will be the controlling law for settling any disputes. 2. Statute of limitations. The statute of limitations determines the amount of time which may pass before the judicial system may no longer be utilized to seek a remedy for a legal claim. Many contracts include clauses that shorten the statute of limitations and are often enforceable if the period is reasonable. 3. Indemnification. An indemnification clause is a provision in which one party agrees to make good for any loss, damage, or liability incurred by another. For example, a buyer of a business will often require an indemnity clause that requires the seller to make good for any liabilities that arise from actions or events that occurred prior to the sale of the business. If you are the party that is promising to indemnify the other party, be sure to negotiate a limit as to the maximum amount that you may be liable. 4. Time of performance. In contracts where time is of the essence, it is important to include a clause that requires that performance be tendered at a specific time. In a contract with a specific period for performance, a party has breached and may be sued for breach of contract if he has not performed his duties at the required time. 5. Arbitration. Arbitration clauses require that any disputes arising from a contract be resolved through binding arbitration, which means that the parties may not use the judicial system as a means to become whole. Negotiating away your right to utilize the judicial system to obtain a remedy should not be done hastily. 6. Liquidated damages. A contract may stipulate the amount of damages to be recovered in the event of a breach. It is important to know that liquidated damages clauses are generally only valid when, at the time of the contract, the amount of possible damages for any future breach would be difficult to determine and, at the time of contract, the amount of liquidated damages stipulated in the clause is a reasonable forecast of potential damages. Therefore, any liquidation clause that is unreasonable or appears to be a penalty will likely not be enforced. 7. Attorney fees. A good contract will require the losing party in a breach of contract claim to reimburse the prevailing party for reasonable attorney fees. A clause to pay attorney fees generally deters parties from acting or litigating in bad faith. 8. Merger and integration. Most contracts will state that the contract document contains the entire agreement and that the parties are not relying on any statements or promises from the other party that are not also included within the document. It is important to make sure that all promises, representations, and warranties are included within the text of the contract, especially when dealing with a contract that has a merger clause. 9. Severability. The severability clause is also referred to as the savings clause, and it protects the enforceable parts of a contract in situations where one or more parts are judicially declared to be void or unenforceable. Savings clauses are extremely important and should be included in every contract. 10. Non-waiver. A non-waiver clause protects a party who excuses performance from another party and reserves his right to enforce at a later date any contract provisions that he may have allowed to go unperformed. However, without a non-waiver clause, it is possible to lose your right to enforce a contract provision that you did not enforce previously. Non-waiver clauses should also be included in every contract.